introduction because we're going to get to those later. We have Brian Douglas, who's the founder of Beneficent Media. He's one of our speakers. And then let me just get to the introductions of our first speakers from New Media Rights. We had a meeting about a year ago on intellectual property and copyright. And after the meeting, what we heard sort of unanimously was we need to continue that conversation because there's so much to talk about. There are so many ways that we can do it right, and there are so many ways that we can get ourselves in trouble by not doing the documentation correctly. So I'd like to introduce very briefly Erica Lee, who is a staff attorney at New Media Rights, and Sean Spalding, who is the assistant director and also an attorney. And they are going to talk to us tonight about IP contracts, copyright, and just everything legal. So here we go. I think you guys have mics on, so I will step away.
Can everyone hear me okay? Awesome. I won't stand in front of the projector because that's a great image. So this is great. So it sounds like we have a lot of different people in the room doing a bunch of different creative types of work in various different fields. Just to jump to a little bit about who we are and what we do, we are an independently funded program of California Western School of Law. And there are three big components to what we do. So first, and primarily, we offer one-to-one direct legal services on a free and reduced fee basis. We also have various educational videos and guides that we've produced over the years. Those can all be found on our website. We also have a book that we've released that is a kind of a plain English digestion of a lot of these complicated issues that we see very frequently. And third, we also engage in public policy work. So for instance, most recently, we worked on submitting some comments to the Copyright Office, advocating for various ways that we can change the way that we actually register our copyrights using the online system. We've worked with a lot of different clients kind of on the ground in that space, and so we found ourselves in a very unique position to be able to advocate for those individuals. So that's a little bit of a taste about what we do in general. And in terms of specific types of services that we offer for filmmakers and for folks working in video production, we offer pre-publication reviews. So if you need a fair use review or a copyright clearance to get your errors and omissions insurance, that's something that we're actually particularly known for. We also draft and review various types of contracts, from employment and independent contractor agreements to various different content licenses that you might need or need to give away. And we also deal with video and photo releases, various notices that you might need for shooting in crowds or in public spaces. And then one other thing that we are also known for is our work with DMCA takedowns. So we work a lot with YouTube creators who have their content taken down and they need help to either argue for fair use or get their account back up. And so that's kind of a little sampling of some of the things that we do on the day-to-day basis. So our focus today, and I know some of you were here the last time we were here, so I'm going to kind of move fairly quickly through some of the basic copyright principles so that we can get to the contracts and using your creative content as leverage when you have various different types of agreements going on here. All right. Okay, so at its core, and I'm going to step over here, copyright law is designed to protect your creative expressions, right? But on the other hand, it's also designed to protect everybody else's creative expressions. And so we like to think of copyright as a series of inputs and outputs. We create things today, we create outputs that future generations are going to want to use as inputs for their own creative works. And so in this context, you can think of creativity as that series of building blocks. And we need the ability to be able to actually innovate, to actually be able to build on one another's works. And so this is where copyright law comes in. It basically can incentivize people to create new things while at the same time putting some restrictions on what you can and cannot do with other people's content. So one of the ways that copyright law incentivizes people to create new things is to give the copyright owner a series of exclusive rights. So those rights are to reproduce, distribute, create derivative works of, and perform or display the content. So reproduction, that's just making copies. Distribution, that could include more of the traditional distribution, like broadcasting something or selling physical copies of your content. But it also includes putting things up on the internet and social media and spreading things that way. Derivative works are new works that are based on an original. So classic example of this is a film that's based on a novel, for instance. So in recent history, Ready Player One, for example, Ernest Cline, the author there, as the copyright owner, or I guess probably technically his publisher, is the only person in the world who can authorize Steven Spielberg and his production company to go ahead and make that blockbuster Ready Player One film. But these rights don't last forever, right? Copyright law lasts for 70 years after the death of the creator. And then also if it's corporate authorship, that timeline changes a little bit. It's 95 years from the date of publication, or I believe it's 120 from creation. And I think it's like whichever one expires. Yeah, it's a long time. The short of it is a long time, but it's not forever. So if you want to go to the next slide, thank you. So let's talk a little bit about what is actually protected by copyright law. And the key part to remember here is that there has to be an expression for something to be protected. Ideas are not protected by copyright law. And this can be a really important distinction. And it's essentially why we can have all these different superhero blockbuster movies, right? If Marvel, for example, were to have this monopoly, this creative, or this copyright over the idea of a superhero movie, then we wouldn't have Batman or Superman or even Aquaman. And so it can be really important to encourage creativity that we do not allow people to protect those ideas. But once you've fleshed something out, once you've started typing your screenplay or creating the mock-up of your first production stills or even starting to shoot your content, that expression is what is actually protected. So on the screen you see examples of, oh, well now we have not protected, but protected works include books, movies, scripts, songs, exactly pretty much anything that you create that's original and fixed in a tangible medium of expression or just saved in some format, and that includes digitally as well. All right, so now let's talk a little bit about what's not protected by copyright law. Ideas, we've already talked about that, not protected. Facts are also not protected. And this is also important too. Facts are considered to be in the public domain. So this is why we can have multiple reporters reporting on the same issues that are happening day to day. But it's that specific journalist's article that's actually protected. So you couldn't copy and paste someone's article and put it up on your blog because that specific expression of the public domain facts is protected. Titles, names, short slogans and phrases, those are not protected by copyright law, but they might be protected by trademarks, so they're not just completely unprotected. Then federal government works. This one is pretty important, actually. So federal government works are also considered to be in the public domain, meaning that they're freely available to use. But the slight caveat here is we all know that the government likes to contract work out to private individuals. And so you have to make sure that what you're trying to use is actually something that comes from an office of the federal government. And then other works in the public domain are also not protected by copyright law. So public domain, like I said, means that it's freely available to use, either because it's basically run its lifespan, or if it was published prior to 1923, that's considered to be in the public domain and freely available to use. Now, public domain can be a little tricky to figure out. Obviously, those things prior to 1923 are a little bit easier. But some things that were created between 1923 and like 1978, there were certain various changing requirements to receive copyright protection that required putting like Circle C and your name and the year it was published. And if you didn't have those, what were called notice formalities, then your work slipped into the public domain. So if you have questions about public domain, whether something is or is not, that's the time when you can reach out to an attorney who may be able to help you figure that out. All right, so what does all of this mean for you as a creator for your own work? It means that you have the copyright to any original content that you create. So remember, I said has to be original, has to be fixed in a tangible medium of expression. You don't need to register your work or provide notice to receive copyright protection, but registration can be pretty important, and we'll talk about that on the next slide. But the other key thing that this all means for you as a creator is that you have the power to grant out licenses, and you have the power to completely transfer your ownership to your content. And so I'm sure you guys probably know what a license and an assignment are, but just so that we're all on the same page, a license is a grant of permission to exercise some of those certain exclusive rights that the copyright holder has. It can be broad, it can be quite specific. They kind of run the gamut and they vary depending on the different terms and what you're doing, or what the other person is doing who wants to use your content. And then an assignment is a permanent transfer of all ownership rights. You do not retain any rights over the content at all, whereas with a license you retain your ownership, but you just give permission to do certain things. Okay, so the big question, should I register my work? And then if so, when should I do it? The answer here is yes, if you want to enforce your rights, mostly on a formal basis, but also if you want to enforce your rights in more of an informal basis, registration can be important. And there's two main reasons for this. It's because you can receive one, statutory damages, which is basically the monetary award that's more or less guaranteed if a court finds in your favor. And so these damages, as you can see here on screen, you can get up to $150,000 per infringement if it's willful, meaning that you did it with knowledge, like you're a bad actor. And then even for infringements that are not willful, statutory damages are available that range between like $750 to $30,000. So there's a chunk of money that's available there in the event that someone were to infringe your works. And then in terms, and then also the other main reason here is attorney's fees. These types of lawsuits can be quite expensive, time-consuming, resource draining, and so the attorney's fee award can be important to actually even lock down an attorney to help you litigate this case. Actually, most attorneys are not willing to take on a litigation case if you're not registered. And so this is why the timing element can be really important with registration too. So the rule is that if you register before the infringement or within 3 months of publication, and that 3-month window is like, let's say you published your work, but you didn't register yet, and then someone started infringing your work. So technically, if you were under that rule that says, oh, you need to register before infringement, you're like, what do I do now? There's this weird window where someone was still infringing my work, but I didn't have it registered. So that's where that 3-month rule kicks in. So like if you find someone's been infringing your work, as long as you can register within that 3-month window of publication, then you are eligible for statutory damages and attorney's fees. And so how to register, you can do that online at copyright.gov. There are certain different options for, like if you want to register things in a group, to do that to save on cost and on paperwork as well. However, currently for videos, just so you know, there isn't a registration option for things that have already been published. There's only that option for unpublished group registrations of video content. So that's something to keep in mind too. All right, so what does all this mean for you as someone who wants to use somebody else's work in your own projects? Essentially, it means that you don't have any ownership rights to anything that you didn't create yourself. So if you're trying to use audio, video, images, any content from a third-party source, you need to either get a license, make sure that it's in the public domain, or use it under fair use. That was a quick slide. So a little bit about getting a license. Generally, you'll need to negotiate with the copyright holder directly because the various specific terms of those licenses can vary depending on what you're doing. But there is a lot of openly licensed content out on the internet, and we've included a couple examples up on screen here. But if you go to our website, newmediarights.org, we have a couple of different guides that have additional resources if you're looking for openly licensed content as well. Or you can just contact us as well. Okay, so I want to talk very specifically about music, because music is one of the most difficult pieces of creative content to deal with from a licensing perspective. And the reason for this is because a song is made up of two parts. You have the composition, which is the lyrics and the notes on the sheet music, and then you have the sound recording. And because each of these different sides are often created by different people, copyright law protects them separately. And they each have their own bundle of rights attached to them. So, for example, if you wanted to use a song for a soundtrack to a short film that you're working on, you would generally need at least one license for each side of that equation, right? So, and then depending on how exactly you are distributing that song, you might need more than one on the composition side. So typically, you need a synchronization license for the composition side, which gives you the permission to use the composition in sync with the video file. And then on the sound recording side, you generally need the master use license just to use that audio recording. And so like I said, same here, licensing can vary tremendously, but you can negotiate and get some sort of reduced fee. And the best thing that you need to know here is that if you can just tell the licensor everything that you want to do with the content, you'll be able to get the most effective rights that you actually need. So if you know that you're going to submit to a film festival, or you just want to put this up online and make it available for digital downloads, or you want to do film festivals and eventually streaming or sell DVDs, these are all things that you should be discussing with the licensor. So it's worth taking a few moments to think about how exactly you're using your content, both in your project, but on a broader spectrum and a bigger picture. Okay, so other ways that you can reuse content without a license, as I mentioned before: public domain, anything published prior to 1923, or fair use, which we won't get too much into the weeds on today, but it allows the public to use certain portions of copyrighted content without permission for very certain instances. And so I think with that, I'm going to hand it over and we'll start talking about some of the contract-specific applications of copyright law.
Hey! I'm really into contracts. Before I became an attorney, I used to be a filmmaker. At one point, I was working as a producer. I was trying to produce a documentary about contracts. That's how much I like contracts. And so, I'd like to make sure that this doesn't just feel like you're watching a YouTube video or something. So feel free to throw questions at us while we're speaking, just because if you're here in person, you might as well get some feedback and interaction, things like that. All right, so very, very big picture questions. Let's not think about contracts as a piece of paper, as a technicality, as something that you just sort of sign off on, that you copy and paste from the internet. Think about a contract as a relationship between two people, and then suddenly it becomes more interesting, more understandable. All of the words on the page mean something, and then that meaning relates to how you are going to interact. And so this seems like highly theoretical, but it's going to come back, I swear. All right. Okay, so contracts can alter some of the basic rules that Erica was talking about copyright ownership. For example, if I have an option purchase contract and I say that, hey, you can buy my screenplay if if a production company wants to come along and produce my movie. And that option purchase has an assignment in it that says, hey, now I, writer, don't own the screenplay anymore. You, production company, own it. Suddenly, I don't own anything. However, contractually, I can say that you might own this screenplay, but you can't actually make a movie without allowing me to sign off on it. You can't make a sequel without me being part of the production still. You can't make a novelization, a derivative work, without me being the writer on it. So suddenly, a contract can change how a copyright owner can use their copyrights. Another big picture idea, always get things in writing when you can, but the writing doesn't necessarily have to be a formal contract that a lawyer puts together and that has wheretofores and hereins and everything like that. A contract is literally three things. It's an offer. Hey, can you mow my lawn on Tuesday? An acceptance. Yes, I'll mow your lawn on Tuesday. And consideration. We both decided that we were going to do something on Tuesday. I was going to mow your lawn and you were going to give me money, right? So that's a contract. And so there's this whole continuum of what a contract actually is. Emails that you send back and forth between the DP that you're trying to hire before you hire them. That could be a contract if you don't actually have a signed writing. If you say, hey, I will give you X credit, and then you don't give X credit and you didn't have any contract that says to the contrary, then you owe that person X credit. And so it's really important to understand that, let's say you're trying to clear something for a documentary, right? You might not be able to go back and get some sort of license or release from someone because maybe they won't sign it, maybe they've disappeared, but maybe you do have an email that says, yes, you can use this for your documentary, or yes, you have certain rights to use this, and suddenly that can become the contract that's necessary to move forward instead of having a formalized contract. All right. When you're doing commercial projects, don't start work until you have signed contracts with everyone, ideally. And so, of course, it matters a lot what those contracts say, but generally having a contract is better than not having a contract. Oh, go for it.
Yeah, I have a question here, and I've encountered this already, and it worked out okay. I have a very oriental style of talking about a project. I don't know if you've ever done business with people from Japan. I used to live in the Orient, so that's where I got this style. Basically, somebody's telling me, it's like, okay, I want this right, and I want this condition, and that, and I'm going, yes, okay, sounds good, They think I'm agreeing with them, but I'm not. I'm not, but what I'm really saying is I hear you.
Mm-hmm.
And I'm wondering, at what point do I need to make clear to people that this is the case? Because I went into a contract negotiation, and they kept saying, oh, but Sandra agreed to it. I just stop them and say, no, wait a second, no, this is my attorney over here. He does the negotiations, so you're mistaking my style. That's an Oriental business style, okay? No, it was not in writing, so no, I was not agreeing with you, I was understanding you. At what point do I bring that up?
So this is why it's really useful to have a signed contract, because typically commercial contracts are going to have something at the end called a merger clause, or an entire agreement clause. Usually it's sort of whatever heading says full agreement, something like that. And so what that's saying is that it doesn't matter all of the conversations that we had previously. I could have said something the opposite of what's in this contract, but now, since this paragraph is in this contract, only the four walls of the contract and what is said here is our actual agreement.
Called again?
It's called a merger clause.
Merger clause?
It's also labeled entire agreement sometimes. It's usually one of the last paragraphs in commercial contracts. And so that suddenly destroys any reliance on any sort of conversations beforehand. If you don't have a signed contract with one of those in it, then every conversation becomes a gray area. every conversation becomes a point where to say, well,
Yeah,
you,
yeah, I make it clear that I want the signed contract, I just
Right.
want to generally know what you want ahead of time, so I know where I stand on it. And they mistake my style, when do I need to let them know, oh, well, wait a second, I've got an oriental business style, you need to know I'm not agreeing with you in actuality.
Yeah, one thing that's interesting is that getting a signed contract is really important because it saves time in terms of your disputes later on, because one person might say, oh, I think that you said that we'd all have 10 shooting days instead of 8, and now you owe me 2 more days of money or whatever. And so the less gray areas there are, the less disputes you have, and sort of the less time you have to deal with administrative tasks if you have clear contracts that are signed ahead of time. And so,
And also to build on that from at least like a copyright perspective, it's actually in statute that in order to transfer ownership rights to a copyright, there has to be something in writing that's signed by the original owner, and then it has to clearly show the intent to transfer ownership. So, you know, when you're talking about kind of these conversations, these conversations that are going on beforehand, this is why, you know, having that written contract that clearly states, like you could even say it is the owner's intent to fully transfer ownership. But again, like the key part there is going to be both the writing, the signature, and the intent in the writing. Yeah.
What's that called again, merger clause or?
yeah, entire agreement clause.
Entire agreement clause.
So one of the last sort of really big picture theoretical things before we sort of dive into more practical things is that there's no such thing as a standard contract. And so a lot of people say, oh, this is our standard contract, take it or leave it. And it's only meant to be standard if it's not standard anymore, if it's only meant to be standard if you don't have the power to negotiate or the interest to negotiate. And so I even tell students that I work with to put standard on the top of certain contracts, because suddenly it discourages people from negotiating it, believing that, oh, this is standard, so there's no changing it. All right, so one of the most important things to commercial filmmakers is copyright and copyright transfers and licenses, because you both need to get licenses to do your work if you're making a documentary or making a industrial video where they're offering you lots of different photographs and things like that that you're putting in. But at the same time, you're also, the most valuable part of what you do is the intellectual property that you deliver, like as a commercial industrial filmmaker or a corporate filmmaker, you're making commercials, because what you're giving them is copyright. That's what you're selling to them at the end of the day. And so it's worth talking about what it means to sell a copyright, what it means to license a copyright. And so an assignment, as Erica was saying, is a full transfer, and then a license is anything less than a full transfer. So there's 2 major types of licenses. There's exclusive and non-exclusive licenses. And so an exclusive license means that you don't own it. I mean, the person I'm transferring it to, that person doesn't own it necessarily, but that person is the only person that can do certain things with it. And so, for example, if I were making a documentary and I wanted to distribute the documentary, I could give an exclusive license to Netflix, and Netflix is now the only player who can distribute my documentary because they have an exclusive license to it. Or I can give a non-exclusive license to Netflix, as well as a non-exclusive license to Amazon and a non-exclusive license to Apple, etc. Because if I give away non-exclusive licenses, then I can give it to anyone. So in your licenses, the licenses that you get, you want them to be extremely broad, and in the licenses that you give, you generally want them to be very narrow. And so the places where they can be narrow are in duration, so how long they last, geographic area. Is it worldwide? or is it just in the United States? Is it going to be for only English-speaking countries? Is it going to be for all of Latin America? So there's lots of different ways that you can narrow or increase the scope of the license. And so one thing that's really important is the fact that if someone wants more of your copyrights, it can be actually a value add. It can be something that you sell. And so in the web design world, we often see people who will give away a license to the things that they design. And then if the client wants a full transfer of all rights, then that costs more money. And so if you're sort of a commercial filmmaker, that might be a value center where you can start actually selling licenses and then adding an extra amount of money if they actually want ownership. I think that, let's go to something more meaty. All right, so let's look at some actual contract language. This is interesting because this is probably from a contract where someone is making a corporate video for someone, and the company is providing them video, providing them maybe photographs, providing them maybe audio or a script that they can use. And so these things need to be integrated into the final product. And so the portion in orange, which maybe you can't read because it's so tiny, the portion in orange is the notable portion, because what this is saying is that the company is giving you all of these materials. However, the company is also making no representations or statements about whether or not those materials are going to be infringing. So maybe they're giving you things that will actually get you in trouble once you deliver the final result. So they're saying that it's your sole responsibility to determine whether or not the stuff that we've given you is useful for its purposes. And so that seems really weird, right? It's like, oh, if we're giving you 100 photographs and we're telling you to put it in there, but then we're also saying in our contract that those 100 photographs may or may not be infringing, and it's on you to figure it out. That seems weird, but it's sort of par for the course in many of these agreements. And so what can be learned from something like this? So number one, know what these things say, read your contracts. If there's no other tip, it's read every sentence very carefully and then ask yourself, do you understand what this means? Because if you don't, then you can just Google it and figure it out. And also read the contract as if you don't know what words mean, because I think that when you have a lot of experience, you look at an agreement and you say, oh yeah, no problem, I know what that paragraph means. But did a sneaky lawyer throw a sentence into that paragraph that you've never seen before, or a word that you've never seen before? Lawyers are very sneaky, and we do things like that all the time, and we do things like this, where we give people photographs and say it's on you to figure out whether or not it's actually infringing, even though you have no way of doing that. How would you change something like this? Maybe you can take it out. Maybe you can negotiate it out. A lot of people sort of have this hesitance to negotiate out points like this because it's not necessarily material to how much am I getting paid, when do I have to show up, how many revisions do I need, sort of these business terms that are very important to filmmakers. And so this might be just some oversight that says, okay, sure, why would they give me photographs that they can't use? However, when you think about this in the context of other things that might be in the agreement, for example, an indemnification clause, which says that if a third party for some reason gets mad at us, then if you didn't do everything that we told you, you are on the hook for paying for however much damage happens to me. And so this is a huge problem because they've essentially given you a landmine that you have to sit on and hope doesn't go off. And so, okay, so again, it's sort of like still a very theoretical problem. Because let's say I run a small production company, our revenues are less than $500,000 a year, like we're doing okay, but we're not huge. It's like, who's gonna really sue us? And so for the most part, no one, right? But you're making a corporate video for GE, and they ask you to use a photograph that is owned by some third party. Let's say it was like some surfer they got off of Instagram, and they used his face and name, and they said, oh, we're making a surfing video. Our CEO loves surfing. Put it in the corporate video. And so you do it, and that surfer gets really upset and then sues GE, which they will, because there's a ton of money in suing GE. So once you get the indemnification triggered, suddenly no one cares about suing you, but GE cares about making their money back from the lawsuit that happened to them. And so I know that's sort of convoluted, but go for it.
That phrase, safe and proper condition, I'm looking at that wondering how does that pertain to copyright? And is that just me as what I'm incumbent to be looking at, say, this could mean anything, this could mean copyright, and then go to them and say, we need to change this wording? Is that what you're suggesting?
And so I don't think you necessarily need to change this wording, but because this is sort of like a theoretical problem. But the indemnification is the real world problem. The indemnification can be triggered by this or any sort of other weirdness that they put into the agreement. And so let's look more into indemnifications. So indemnification is the act of compensating for loss or damage. And so this is a typical example of an indemnification clause. Filmmaker agrees to hold harmless and indemnify the company against any claim, demand, or suit, blah, 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 blah. And so any claim, even a frivolous claim that the person you made the content for, if that person ends up getting in trouble or getting sued or even getting a demand letter that they have to hire a lawyer to pay for, then they can say, you have to pay for all of my legal expenses that go into this. This is really bad because you could work on a $10,000 contract that then leads to a $50,000 legal dispute. It's like you don't want to necessarily be in the way of that, and the $10,000 you made on the contract wasn't necessarily worth the $50,000 of hassle that came from it. And so instead of editing this, because on some level, who cares about it? You edit this because this is one of the central places where money might actually go out of your pocket. All right, so in red down here, it says you agree to indemnify and hold harmless publication and its affiliates from any loss or liability incurred as a result of any breach of the, let's not look at that.
I'm already asleep.
All right, let's look at this one instead, because this one is so easy. All right, so at the end of this, it says, we will indemnify you for any claims of infringement of copyright, libel, obscenity, etc. Right? There's a list of stuff. If you want to change it, shorten the list. And shorten the list to the things that you're actually concerned about. So for example, if you see this in here that they've given you a bunch of IP that you don't know whether or not someone owns it or they own it, and they won't give you any guarantees, either formal or informal, that this stuff can actually be used, you tell them, yes, I will indemnify you, but not for infringement of copyright. I would like you to X out 3 words. And so it's those 3 words that now, if there is a copyright infringement suit based on this, you're no longer indemnifying them, right? Your liability has gone from this $50,000 sort of defense against this company to 0, just because you eliminated those 3 words. And so one of the, I guess, takeaways of how to think about editing your contracts is think about the fewest words that you can take out to get the result that you want. And so we could have tried to edit out the entire thing. Maybe they wouldn't have been receptive to that at all. But between editing out a paragraph and editing out 3 words, who knows? Let's try to edit out 1 word. Let's try to edit out the word indemnify. So filmmaker agrees to hold harmless and indemnify the company. Hold harmless and indemnify are 2 different independent legal concepts. Each one costs you more money. And so, for example, if I hold you harmless, that means I can't blame you for what you did. But it doesn't necessarily mean I have to pay for it. And so, if I'm choosing between what the most expensive thing for me is in this indemnification provision, it's easily indemnification, I'll edit out 1 word. And so you get sued for having this infringing photo that you told me to put in there, and you trigger this indemnification clause, I will hold you harmless. I won't go in court and say they told me to do it and they're cheaters and they deserve everything they get. I'll hold you harmless, but I won't pay for it. I won't indemnify you. And so Xing out 1 word suddenly creates this huge sea change in how this relationship is actually happening. Let's look at something else. Representations and warranties. All right, these things are interesting because they're in all these agreements and sort of everything. Like, if you've signed any commercial agreement, you've seen the idea of we guarantee that we'll follow every law and we guarantee that everything that we say in this contract is true, blah, blah, blah. And so what do these things actually mean? Why are they there? And why are lawyers like me putting these things into the agreements, even though, I don't know, we know that you probably don't follow every single law. Like, are you going to speed on your way to work? You totally violated the contract.
I'm sorry, I've got another question here.
Yeah, go for it.
What if I wanted, okay, I do put messages into my work. What if I want to portray white supremacists in a bad light? Okay. Yeah, sorry to ask another question here. I do put messages sometimes into my work. What if I want to do something like portray white supremacy in a bad light? Can I be sued by some white supremacist group for, kind of tongue-in-cheek doing it? I didn't do it overtly, but it's there.
It's a different, that's something different because I guess that matters about how much creative control you have over the project, and that's really a business term. It's like if you're doing commercial work,
So if I cast these people as the bad guys, that's my way of saying I don't like those people.
Well, I mean, I guess the contract stuff doesn't matter as much because it really matters just if you're doing like industrial work, for example, or corporate work, and it says that corporation has final say over the creative aspects and the aesthetics of the shoot, then they can tell you whatever they want.
Yeah, but it's my work, that I'm putting out there. I am the corporation.
And so if you had if you have a creative control portion of a commercial contract that you're working in, maybe you should change it to, hey, I will do certain things and you have to agree to it, and then that's how you end up editing the agreement to.
No, I'm sorry. I don't feel it was answered, but we'll pass. Go
Oh
on.
yeah. We'll talk.
No, it's just like I put messages in my work. I do put messages in my work. And it's like I will say white supremacy is bad. I don't come out and say it. I don't draw little arrows to say bad guy and he stinks and little flies and things like that. But yeah, if I cast them as the bad guys, can some white supremacist group come sue me for like defamation of character, even though I wasn't specifically after them? It's just I disapprove of white supremacists in general.
Sort of outside of the scope of the contract conversation, but generally, I mean, we have a pretty wide latitude for making creative work in films about the things that I mean, the First Amendment sort of gives you a lot of latitude in terms of what you can say. And so if you can say it, someone else can't necessarily complain about it. Defamation happens, for example, if you say something untrue, like patently false about someone, and you have sort of this negligent interest in not saying something true about it. It's
Okay,
like
now
if
I follow you,
yeah.
thank you.
Oh, okay. Now I get the question. Yeah.
My question is a little more general than that. I personally have never signed a commercial contract. Has anyone? Like for a commercial film, like for something that includes all the legalese. Okay. So for most of us in the room, I dare say, I've signed very simple contracts. As a makeup artist, generally what I've seen in the few contracts I've been asked to sign on film projects, there's usually a clause in there that I give permission for my images or images of my work to be used. That's it. I'm the only makeup artist that I know of that actually issues a contract for my work. My contract is in very plain English, and it covers the who, what, when, how, and why. Generally, in most cases, I do my work according to a director's instructions as to what they want their characters to look like. There are a few projects where I have creative license. To that end, if I have the creative license to do someone's makeup, does that mean I need to copyright my work? Do I get a copyright within that work or not?
So that's a big, interesting question, and we can't answer specifically to your situation just because of all the confidentiality stuff. However, yeah, I think that number one, anytime someone makes a creative work, they automatically get copyright protection as long as it's original and fixed in a tangible medium, like Erica was saying. And so for the most part, makeup is probably going to be copyright protectable. And so the first thing is it your independently generated design? Or is it a derivative work of the screenplay saying, for example, let's use the Joker as a character from Batman. It's like if the screenplay says, oh, he wears corpse paint and he is green and he has slicked back green hair, and so the more that the makeup comes from the screenplay and comes from the previous works, it could be considered a derivative work of the existing copyright. So it may not be, your design may not actually be your copyright. So there's the first portion of it, which is many makeup designs are going to be copyright protected. The second thing is sometimes makeup designs come from other influences from other places, and so in those situations, maybe the person who made the original, so the screenplay, owns that derivative work. And then finally, yeah, I think it's really great if someone who does makeup registers their work, if they think they have a really iconic design. I think that it's also somewhere where if you're a filmmaker working with a makeup artist who's bringing a lot of independent creativity to the table, that you get a release from them such that you own the copyrights to their work, because I imagine that if someone essentially did production design for you by creating the look of your film through makeup, then that's really important to own as a filmmaker if you want to be able to release it, and you don't necessarily want makeup artists to say, hey, I own a piece of the copyright of your film, which they legitimately could if you didn't get a release from that makeup artist. So I don't know if that sort of answers your questions in general or approaches an answer.
It does. Thank you.
All right, representations and warranties. And so a representation is, imagine a contract as day zero, right? Everything after we sign this contract we're all going to do. That's why we have shall. Shall is in the present tense. After the signing of this contract, I shall shoot X amount of video for you. I shall be an actor in your film, etc. Before that is representations, right? I make a representation that says, everything that I've done in the production of this project before distribution has been legal. And then I have a warranty that says, everything after this production will still be legal and follow the law, and I won't do anything wrong after that. And so this is a typical representation and warranty. So you're saying that throughout the entire in a distribution contract, throughout the entire life cycle of this production, nothing bad has ever happened ever that could be considered illegal. And so this is a huge bar. This is a huge wall to climb, because at some point, someone must have broken the fire code by plugging in way too many lights. And as soon as anything happens where you have some sort of breach of this warranty, someone has the ability to sue you under the contract, to potentially invalidate certain parts of the contract, to challenge the contract in court and get negotiation leverage over you. And even before any of this gets to court, because very few people are sued and very few people who are sued even get to court, violating a representation warranty is going to give someone a reason to pretend as if the contract is not valid anymore. And so every time you look at your representations and warranties, that section in the agreements that you sign, you should be very careful, because you should read it and say, am I, by agreeing to these words and then signing this, am I literally breaching this contract upon signing, right? It's like, if they're saying that you warrant that you have licenses for every single person who appeared in your, releases for every single person who appeared in your documentary, and then out of the 100 people in your documentary, 99 of them have releases, and then one of them is your mom who doesn't have a release, then yes, you've literally breached this upon execution, because you didn't have releases for everyone. And so, again, theoretical problem, right? Like, oh, we don't have releases for things all the time. We don't have licenses for things all the time. But it goes back to the indemnification problem. If you're indemnifying someone and you're saying anything that goes wrong will be held responsible for, as soon as you have one little breach in one of the representations or one little breach in the warranties, we now have a trigger to get you to indemnify us. And so this is, again, sort of how these things start to relate, how these things start to show where are the places where you should actually negotiate. So right now I brought up two different issues. So the issue of companies, corporations giving you stuff that you should put into your work, and then it ends up being infringing. And I've also given you a completely seemingly unrelated situation where you're representing that you're going to follow every single law. But both of them actually weren't the problem. The problem was that as soon as you breached either of these things by mistake or because they forced you to, you had to indemnify them. And so there are many, I guess one of the big takeaways, and I don't know how much time we have left to talk. Oh, okay, yeah. So, one of the biggest takeaways is there are parts of the agreement that matter, and there are parts that don't. And so some of the parts of the agreement that matter only matter because other parts matter more. And so figuring out things like these indemnifications, figuring out things like representations and warranties, kill fees, termination events, those things are going to matter a lot. And so if you get the things that matter, everything else falls into place, even if you don't understand it. And I think that's all I got. All right. Yeah. So do we just stand
There we
here?
go. There's Mike. Thank you, Sean, and thank you, Erica. So I have been on the receiving end of 10 to 15 page contracts full of all of these various details. And I've always read the indemnification clause, and now I know that that is possibly the most important clause in the entire contract. So thank you for that. I'm going to look at all of them differently. Thank you, Erica. Thank you, Sean. And now we're going to transition to Brian Douglas, who is the founder of Beneficent Media. And Brian's here to talk to us about, as you're seeing on the screen, things I wish I knew when I started a video production business. All of those daily details that I'm guessing, Brian, some of them you've learned the easy way and some of them you have learned the hard way. Mostly the hard way is what he's saying. So we'll just get his mic on. And here's Brian Douglas.
Let me get this plugged in here, make sure this stays while I can get to see if it stays there. Okay. So yes, things I wish I knew when I started a video production business. So yeah, when Mark Mason contacted me a few weeks back, and he's like, Brian, I need your help. We've been working on some projects together, and it's like, I just need you to come in and talk about how you started your company and how it took over 22 years of what you've learned and just make it in 20 minutes. I'm like, okay, Mark, I'll try. So what I did was I put together the things that I wish I knew, the things that I've learned over the time, and I'll go through them fairly quickly, and then I'd love to answer your questions, okay? So, all right, let's go forward here. So about me, I started in 1986. Yes, in the 80s. Can you believe that? Okay, I know, but that's crazy when I think about it. But I started in 86 and worked in sports, working all things to figure out what I wanted to do. And then I started as a co-owner of Digital Outpost in 96. And I just left in December 31st this year after 22 plus years as a partner and I went independent on my own as Beneficent Media. And I'm able to do things now because I follow these principles that I've learned over the last 20 plus years and more than that of how to maintain good business and keep great relationships and tell great stories. So lessons learned, there's five categories we'll talk about today. You need to learn how to value your product, value what you sell, your time. You have to, so we'll get into that, value versus price. And then, oops, we'll go back. So practice servant leadership, and I'll talk a little bit about that, what that means in your everyday business. I know this is hard, but we're all creative people. Have good accounting, proper invoicing, have a projection worksheet. Oh my gosh. Know what you're going to be doing 10 months from now, if you can, with regular clients and trying to figure out what you're going to earn. Okay? That's all very important about keeping a company going. Just keep moving forward. Find great people and stick with them. Yes, that's key. And then build relationships with your clients. That is the number one thing that I've been able to do over the years. Is it not coming in? Oh, okay.
Or arranging.
Oh, arranging things, okay.
So
Let me stand out here.
stand right about there. Then, no, not that far. Right about,
Okay.
right
Okay,
about there.
that's why I've always been behind the camera and never in front of the camera.
There,
So,
see, I
okay.
can't get a good shot over there, and this is way too high.
Live, right? Live internet, live video? Okay. All right, so first thing, valuing your product. Well, if you kind of see that, if you kind of look to the side a little bit over there.
Well, that doesn't matter. It's the way it looks on.
I know. So create accurate value pricing models. Okay, so don't get caught up in this, farther down, that kind of plays into don't play the race to the bottom game. At Digital Outpost, we grew the company to 25 employees, about $3 to $4 million in revenue, And it was good because it was in a time when big production companies could still make a living in San Diego. The days of big production companies, independent, are gone, okay? Because of this race to the bottom. Everybody can now, so for instance, my very first camera that I bought in 1996 when we started the company was a digital Betacam, standard definition. It was $55,000. The very first lens was a Fujinon, okay, 8.5 by 5, a wide angle, and it was $25,000, okay? And the Sackler tripod that it was on was $8,000. And the Shure mixer was another, and the wireless mics were another, well, wireless wasn't even that great then, but this is 96. So it cost me as an individual, with the 4 or 5 of us that were in the business, just to get in the production game was $120,000, just to shoot. And then having an Avid, the very first Avid was ever made. How expensive was that? That was another $25,000 to $30,000 just for the little software with it. And then you had to buy all the hardware, which was another $50,000, $60,000. So what I'm saying is the race to the bottom now. It used to be that you needed all these big clients to pay for all these small things. Now you can do everything on your Mac, basically. I can run my whole company off a Mac and a nice camera, and you're at $10,000. So what's happened is the flood of the market. A lot of great creative people have come into the market coming out of school every year, and they're able to charge less and less and less and less for the product. And my point is, don't play the game. Value your product. You're very talented. You have a talent to give. So stick to your guns. Sometimes you may lose business from it, but that's the one thing we never sacrificed over the last 22 years, and I still have, I'm still working with the guys on other projects, but from a producing level, you have to have a value for what you do, and that's the most important thing. Be careful not to under budget your project estimates. It always takes more time and money than you actually think. And yes, I learned that the hard way, many times. I've learned early on that we're not a nonprofit company. So, a for-profit company. And then we race the bottom and have fiscally responsible markups. So if you're going to hire outside labor and you're going to buy equipment and things like that, you need to mark that up. It's your time and effort and money to go into providing that service for the customer. There should be a markup in there as well. A lot of people say, okay, I'm going to hire you for $300 a day to do this. And then I just charge the customer $300. Well, you're losing money. All your time and effort to book them, or if you buy a piece of equipment, you're paying tax and everything. So you need to make money on that. And so that's always an unknown. People always commonly do that. They just they end up losing money. So from the servant leadership side, so I've always practiced this from the day one when I started the company. And it didn't even have a name back then. I didn't really know what it was. But when you practice servant leadership, you have to lead by example. You hire your crews, you lead by example. You set the example, and you expect them to follow it. You support your clients and crew. As in support, I mean like serve them. Like if you have crew that you always work with, you want to make them better. You want to mentor them. You want to give them more training. As an employee, I had a lot of employees over the years, and I always sent them out for training. I always sent them out for learning, because you want to serve them because they will serve you back by serving your customers and making you look better. That's the premise of that. Establish trust. Okay, trust is, it trumps everything when you're competing against video productions in the open market. For instance, I do work for SPAWAR here. I've done it for 20 years almost now. And I've established trust with all these really, really high up people, admirals and things like that, over time, and they choose me over price because they know I'm going to give them a product that's going to be legal, that's going to have copyrights protected, it's going to have the product's going to work, it's going to train the folks that we're doing, and they're happy with the product, and we charge a very we don't gouge them. We have a very fair offer for what our value is to the government, okay? And then be a good listener. It's always, when you're talking to a new customer or a new client, it's better to listen than to talk, because they'll tell you exactly what they need if you just listen. And that's one thing I've practiced over the years, to just sit there and offer things that you can do and let them finish what they're talking about, and then that way you can create their vision, okay? And then practice empathy. If they're having a bad day, if they're having difficulty in deciding what they're going to do, it's always good to be empathetic and to work them through their problems. And that establishes trust, okay? That's my definition of what servant leadership is. So from an accounting perspective, have good accounting, okay? Practice good and accurate accounting. I can't tell you how many times in our early days we would just go to Excel and we would make an invoice and send it out. And finally we learned we need an accounting system, a basic one, but we needed something to where it had our terms, so you accurately put your net 30, net 15, net 60, whatever it is you've negotiated with. You have to have accurate invoicing and accounting. And so the next is have financial projections. Okay, I went through this training for about 6 months, and it was with a group of former CEOs in San Diego. It was called the CEO Roundtable. And I worked with 2 CEOs that were these really they're retired now, but they were really, really successful. And they taught me that, for you to be a successful company and be able to pay payroll and a mortgage and everything, you have to have what's called headlights. And it's a very simple term. You basically make a projection spreadsheet throughout the whole year. You put in all your costs and everything, and then you have estimates. And you put in, if you make an estimate of, say, it's a $10,000 job, and you think you have a 30% probability of getting it, you put 30% in. And then it calculates out what your potential income could be for looking forward in the following year. Now, I do have a blank form of that, so I can send it to people if you like. You can email me. Well, it's a Google spreadsheet. And it's something that once you start getting into working on small projects or large projects, you can know ahead what months are going to be slow. So you know how to their headlights, how to look ahead, okay? Be cautious when hiring crew. As subcontractors, serious workman's comp fines can occur. Okay, this is nothing I've come across over the years. That was supposed to be a topic talked about tonight, I think it was. Contractors versus employees. I have a lot of experience in that. I could probably come back and talk. I could do a whole hour and a half just on that. But to trying to be short and quick tonight, throughout the years of doing Digital Outpost, we had a number of lessons that we learned early from companies that disappeared because of workman's comp and lawsuits. And so from the very beginning, every person that worked for us on a crew, was either an employee or worked for a temp agency. Every single one of them. The actors, it depends on, if they were a subcontractor, there are rules around that, and there's all these legalities about your tools and whether, I'm not an attorney, but I've learned over the years that you have to do things right when you're hiring somebody. Because if you don't, there was a company that was many years ago, I'm not going to say their name, but they hired a grip out of LA, and the grip came and then filed unemployment on them after doing a job. And they weren't put on as an employment, they were put on as an employee, they were put on as just a part-time contract labor, subcontract. And they were sued, and they disbanded their company from it because it was just got to be too expensive. And we learned from that. And we had recently also had an actor 2 or 3 years ago. He got injured. He got injured in the performance of acting. It was a freak accident. And so thank God he was on workman's comp as an employee, because that took care of everything. We could have easily got sued and lost our entire company based upon an accident, a freak accident that happened. What I'm saying is, don't take it seriously when the next time they have a topic about workman's comp issues and things like that. Another side story on that, we were audited twice in the last 10 years by EDD, which is the labor laws here in California. Both times, they were given bad tips from other people, okay? Each one took a month to go through it. And if you have one discrepancy, like you hired a subcontractor that was supposed to be an employee, it's something like a $10,000 fine per instance. It's huge. So the bigger the company you are, the bigger target you are. So if you're a small company, you're probably okay, but you need to really follow those rules, okay? So next topic they have on that, I would definitely learn about that because I lived through it and survived it. I've already talked about accurate voicing payment terms. Okay, finding good people, that's a statement in itself. It takes a long time to find people that will work as hard as you do. It's hard. It's hard to find that. Now everybody shares that same vision, okay? So the first thing to do is when you have your employees or subcontractors, and one thing is the servant leadership, it establishes trust. Trust is everything. Because people trust you, they will work, and do great work for you, and that you don't even have to think about it. It's just the way it works. It's really worked great for me. So serve at their best interests. So if they need some time off, or need some help, or having some trouble, work with them, and see if they're really good people. And then the end goal is to have a team that represents your company in the best possible way or best possible light. Okay? Okay, and then last thing is relationships. These are mostly client type of things. So it's imperative if you want to have a company last, 10, 15, 20 years, that you have, once again, friendship-based relationships, okay? This creates environment of trust. Trust is a big deal for me, as you can tell. It's in every one of my segments here. Long-lasting clients will value your relationship over price. I said that before. That is absolutely true. So when you're competing against somebody else and you're more expensive, your relationship and trust will win most of the time, almost every time, if a great relationship with the customer. And I put this in here at the last minute because I was really figuring out, well, how did I often get to ask this question, how do you find clients? How do you go out there and find people that you can trust? Well, what I've always done is I join boards, nonprofit boards, and you become this kind of cause marketing kind of person on that board. So for instance, I'm on the board of La Jolla Music Society. And they are just finished building an $80 million art center, a performance art center in La Jolla. And I've been on the board for 8 years, and I'm the media person. Okay? So all 50 people on the board, they often look to me as, okay, I know what I help them with video, I help them with their commercials, I help them with setting up all the audio-visual for their events. I kind of am the go-to person. You all can do that too. You find out what you're passionate about. You want to help a nonprofit, and you get on a board and become a responsible person on the board. And you'll learn you'll get to meet people from all walks of life that could use you, and as a vendor, as a person that they trust to give you advice. Okay, so that's how I've done it. I've done probably a dozen or so boards in the last 20 years, and they've all been things I'm passionate about. And don't be afraid to do pro bono work if you're passionate about it. If someone asks you, can you do a free thing for me for this? And we all get to ask that question probably in this business, right? And sometimes you need to say no because you're not passionate about it. If you're passionate about it, you're going to do a great job, and you're going to meet lots of more people to help you out. Okay, that's what's always served me well. And then, key thing: never burn a bridge, no matter how bad it hurts. No matter how much money you lose. Trust me, I have been in a lot of relationships that I really didn't, business relationships that where things went awry, especially because we used to be a DVD manufacturing. We would do editing, we would do programming, we would do DVD titles. And you're talking about rights. Well, how I got around the rights issues is that anybody who asked me to sign a contract, I said, no, here's my terms and conditions. It's 3 pages, you go through it all and you X out the things you don't want. That's how I got around it, because it held me, it put me in the driver's seat. Yeah, I paid for an attorney to help me write that, and it was well worth it. Because when I worked with Qualcomm, when I worked with, GE was a client, I worked with the federal government. They would say, well, you need to adhere to these contract terms. Well, no, I don't. These are my contract terms, and then let's get our lawyers to, well, a lawyer, I'm not a lawyer, but I've read enough contracts in my life to know when I need to bring one in. And so most of the people would just look at our terms and conditions and they're like, oh yeah, just X out this and X out this. We're fine, we're good to go. Qualcomm was famous for that. They would want us to, they'd give us a 30-page thing to sign. And I'm like, I don't have lawyers on staff. Here, this is what we want. And the lawyer would go through it and scratch out a few things, and we'd agree to it, and we'd be done. That's so, never burn a bridge, because in the DVD business, we were given pictures, videos, and everything, but in our terms and conditions, it said, you own all rights to your content delivered to us. That's what you're acknowledging when you sign our terms and conditions. So I don't know if it legally gets around things or not, but that's how we got around it. That's how we worked it. Okay, and then that's it. Any questions? Hopefully I got through it fast enough for you. All right. But please, if you have any questions about business, and ethics and all that fun stuff, I can answer whatever you want me to answer from my experience.
Greg, just a second. Here's a mic.
From the name of your company, what is it that you do?
Okay, so Beneficent Media. I am a creative media consultant now. So I don't want to own production equipment anymore. I don't want to own cameras, and I have crews that I've worked with for over 25 years that I trust, and that I know enough people now in the industry. So now I'm more active as an executive producer now, and I also I still have a lot of training knowledge with the military I've done for so long that I still work in that space as an operator, like a writer and a director, but mostly it's producing and consulting.
How is working with a big military contract like SPAWAR, I guess working with the government and also working with the military, so it's probably relatively sensitive in certain aspects?
Yeah, so it is important when you finally, if you can get a military contract, it's one of the hardest things to do. Luckily, I started 20 years ago when it was a lot easier, because that was when they valued contracts based on what's called best value, where they would put your experience against and your price together, and it would call best value. What happened during the last administration, the last presidency, the last 8 years, they changed that classification to what's called lowest price technically acceptable. So the SBA changed that rule, and so what it enabled basically was a race to the bottom, what I was telling you about. They would go with, instead of someone like me, I would have I have a big 12,000 square foot facility. I've got overhead, I've got employees, I've got all these things. But if you owned a camera and had did a video somewhat like in the government world, you were technically acceptable to a contracting officer. So that was a challenge. And that's why our business slowly declined over those 8 years, because that process now is changing. It's going back to best value with this presidency that this SBA is in. So now my contract work is starting to pick back up again. So it's good. And Beneficent Media, I named it that because what I do is named it. It's to do good for others and to help people. That's kind of what I want to do. So most of my producing that I do is for nonprofits, things that I care about. And so, and then the regular day work I do is DIT work, usually for some of big productions in town, I'll get called in to do, because I know engineering is a very strong point for me. I know everything, a lot of things about technical and engineering. So, anything else?
I have a question. We fly drones on some
Mm-hmm.
of our events, productions that we do, and I've always felt, how do you make sure that you're not going into areas that you shouldn't be videoing? I mean, the drone
Yeah.
is going to capture a lot of things.
Yeah.
How do you deal with the legality of everything?
Well, I just recently, it's funny you asked that, because I just got my Part 107 license.
I'm sorry.
I just got my Part 107 license, FAA test. I went and took it. And it's a license you need for operators to have to be a remote pilot. It's called a remote pilot. And I did that because I've been RC stuff for my whole life, so it's a hobby. But I did it because I own a Mavic Pro now, and I'll keep it in my bag. And if I ever need it, I got my license. And I have an insurance policy under Travelers Insurance for my business license. Has a drone rider on it for $1 million liability or something like that. But that's part of the insurance that I carry to do productions for people. And so how do you know where you're flying? Well, there's a couple apps you can use that will tell you before you fly, and a few others that will tell you if you're in a Class D or Class C or Class B airspace, or it'll tell you you're in a restricted airspace or in a military area. But if you're in those spaces, you can apply now to get a code within 24 hours to see at what elevation you can fly in those areas.
So do you announce to the crowd and say, if you don't want to be a part of this footage, that they can leave when you're flying the drone?
In my experience, because of my nonprofit work with large organizations, they have a sign at the door. I always consult my clients. Like, I work for Center of Performing Arts in Escondido as a consultant, and I help them with their media and their social media stuff. And with the La Jolla Music Society, we have a big sign when people walk in with their tickets saying, "You will be on video. Please, if you do not wish to, be on video, whatever, that's part of entering this event." Okay, so that's one thing that I would do. Yes.
But that is a totally separate subject.
Yeah.
That's a totally separate subject from flying a drone over a
Yes.
crowd, which is illegal.
It's illegal, right? You cannot fly over people as part of the Part 107 license. Yes, you're right. I thought it meant like if you're not flying over people and you're shooting an event type of thing. Yes. Yeah. Anybody?
I was actually gonna talk about the whole thing, but no,
Yeah.
you said most of it.
Yeah. Yeah. You can't fly over people. That's definitely.
But yeah, the one part I would add to that as well is it's mostly about identifiable people,
Right.
and it's about not invading people's privacy, so not videotaping and then publishing things that people wouldn't have wanted you to see. Like if they were at the beach, but they were like, I don't know, urinating on some tree over there, and then you took a picture of them and then published it. Or showing their face in a recognizable way. So one of the sort of standards in California is, could a reasonable person identify this person by face in your video? And if they can, then you potentially have some issues of potentially rights of publicity and privacy things. But until you can recognize someone's face, then if it's a public place and if you're not actually flying it over a crowd like you're not supposed to do, then you have certain leeway.
Right. And so how we've done that with military work, video, I mean, I've worked on $500,000 to $1 million films, training films for the military, training all of our military certain things about going into theater in Iraq and Afghanistan and things like that. And if we're shooting people, we got really good at tracking fuzzy faces on things, or taking out, like, they don't want to have any commercial items. So if you have a Coke can in the back, that's got to be taken out. You got, there's all these things. You don't want to infringe on, show any favoritism to any commercial product on their programs. So, any other questions?
If no other questions, we're going to say thank you to Brian.
All right.
Very interesting.